get the switch over. Unless you all tell me something different, I'm going to, Mr. Kirk's the only person I've got up there at Little Sandy. So if we're ready to go with him, we'll take that case up. Then I think we got one person in Pike County, so we can probably do that one next. Thank you.
Judge, I e-filed the plea paperwork this morning on Kirk.
Okay. Very good. Cardell, you think you're ready to go?
Sir.
Think you're ready?
Sir.
All right. Give me just a minute here. I'm going to change my view where I can get you on. All right, folks, if you're not going to be talking in this one, I'm going to ask you to mute, if you will. Mr. Kirk, will you raise your right hand, please, sir?
Sir.
Do you swear to tell me the truth, so help you God?
Yes, sir.
Thank you. Mr. Kirk, as Mr. Gardner pointed out, I've got several documents here that have been filed, one of which is a motion to enter a guilty plea. Does that look familiar to you?
Sir.
Can you see that? All right. And on the back there, it's got a signature page. And I want to make sure that that's your signature. Is that your signature? All right. Did you read over that before you signed it? Did you have time to discuss it with your attorney if you needed to get any questions answered?
No, sir, but I understand it though.
Okay, you didn't need to ask him any questions? Is that what you're telling me? All right, all right. Mr. Kirk, the Commonwealth's also made an offer right here. It's in writing. It's right here. Do you see it?
Yes, sir.
That look familiar to you?
Yes, sir.
Looks like it's got your signature on it, correct?
Yes, sir.
All right. Did you read that before you signed it?
Yes, sir.
Are you comfortable that you understand everything that's in it?
Yes, sir.
All right. Mr. Kirk, do you feel like you're being made to enter a plea of guilty by me or by anybody else?
No, sir.
Have you reached this agreement voluntarily and of your own free will?
Yes, sir.
All right. Mr. Kirk, do you understand that you have the right not to incriminate yourself, the right to have a jury trial where the Commonwealth has to prove guilt beyond a reasonable doubt, the right to confront and cross-examine witnesses, the right to put evidence on in your own defense, and the right to appeal?
Yes, sir.
Okay. Do you understand that you are waiving each of those rights if you enter this guilty plea?
Hello,
Yes, sir.
not
All right.
much, just in circuit court.
Hold on. Ms. Gardner, can you?
Oh. Hold on a second.
All right. Mr. Kirk, do you feel like your judgment is impaired for any reason?
No, sir.
In this case, the Commonwealth has procured an indictment charging you with promoting contraband first degree, a Class D felony, possession of synthetic drugs, a Class A misdemeanor, and persistent felony offender first degree. The Commonwealth agrees to dismiss persistent felony offender, recommend a 12-month sentence on the synthetic drug charge, and recommend a 1-year sentence on the contraband charge. That would run concurrently. Those two sentences would run concurrently for a total of 1 year. The 1-year sentence would be consecutive with any other sentence that you are serving, and the Commonwealth opposes probation. Is that your understanding of the offer?
Yes, sir.
All right. And is that what you have agreed to accept?
Yes, sir.
All right. Mr. Kirk, are you acknowledging to me that on August the 10th, 2019 in Barron County, you knowingly introduced dangerous contraband into a detention facility constituting the offense of promoting contraband in the first degree, and that you knowingly and unlawfully possessed synthetic drugs?
Yes, sir.
All right. Mr. Kirk, I'm going to accept your guilty plea here today. I find that it has been entered freely, knowingly, intelligently, and voluntarily. You've had advice of counsel. Are you going to ask me to waive a PSI and sentence you today?
Yes, sir.
Okay. Mr. Spears, any objection to that?
No objection, Your Honor.
All right. Mr. Kirk, in light of what I know about the situation and the plea that you just entered, I'm going to, like I said, accept your plea of guilty and will impose this 1-year sentence to run consecutively with any other sentence that you currently have. Do you have any questions about that?
No, sir.
All right. Mr. Kirk, good luck to you. Take care of yourself. Okay? Thank you for your patience. All right. All right. Bye.
Okay.
Looks like I got Mr. Logan up here in Pike County. Does that sound right?
Yep.
We don't have them on yet. All right, I'm gonna go ahead then and.
That's my case, Judge, or
All right, very
cases.
good. Let me track him back down. He moved on me. There he is. All right,
Hey, well, Judge, this was my case, and Mr. Berry had sent me an email this morning about, I had sent an offer, and he had sent me a counter. I just got it this morning, so I think we need to reschedule. I don't have time to think about it.
Yeah. Hey, Ralph,
Yes, sir.
are you serving a federal sentence or state?
No, sir.
Okay, all right.
No, sir.
For some reason, I got word you were on a federal case up there. Okay, never mind.
state sentence.
State sentence. I'm in SAP right now.
All right, understand. Okay, there are 2 cases here to deal with, 20 CR 416 and 20 CR 417. And in both cases, I can pretty easily reschedule it for another pretrial conference. How much time do you want me to, there, Mr. Richardson?
Well, I'm just going to throw out 2 weeks, Judge. I mean, because I may, make a counter to that, and then we might have to talk more about it. So I think 2 weeks is fine.
That's fine with me, Judge.
All right. Mr. Logan, is there anybody there that can hear? Is there anything wrong with 2 weeks from the scheduling standpoint of the jail over there?
No, sir, that's fine. That's fine, yes, sir.
Yeah, we'll follow up with another link and an email and all that good stuff. All right. I just wanted to make sure they didn't have something
Yes,
else.
sir, thank you.
All right. So
Hey, you
that's
are?
February 15th. Yes, sir.
Who's my lawyer?
Me.
Mr. Barry.
Good. Yeah, I tried
Am I
to
gonna be
call
able
you.
'Cause I haven't talked to anybody.
Yeah, I think he's going to need to, that's part of the reason we're going to go out 2 weeks. He needs to have
Yes, sir.
a chance to reach out there and talk to you. Okay.
Thank you.
All right.
All right, God bless y'all.
We'll see you on February 15th. Okay.
All right, thank you, sir.
Bet. Thank you. All right, let's see. Do I have any other detention facilities on here at this point? We've got Butler County, which I think we expect to join in, but they aren't on here yet as far as I can tell. And we've got Kenton County, same issue. So if there isn't anybody else, you all tell me. I'll go to the Barron County Jail unless you have something else you want me to do.
Hey, Judge.
Yes.
On my schedule, it said there's a Samuel Brown and a Linda Choate in Warren County. It's got her in Warren. Or would that be?
Samuel Brown got out of Warren County Jail, so he's not there. And I don't have Linda Choate on the docket. I mean,
This
she's on the docket, but I don't have her on the jail list. And now, that being said, we're joining up with with Warren County this afternoon. So if we want to put her on this afternoon, try to get them to bring her into the hearing room up there, we can try that.
Thank you, sir.
My understanding, I remember that we got violation report was that she was obligated, if my memory serves, to get an assessment and to comply with treatment. And it seems like to me that that doesn't require a hearing. She just ought to comply with treatment.
Okay.
If she wants a hearing, she was released. She had a warrant. Well, I mean, that doesn't mean she didn't get released, but she ought to have been. All right, well, if she's still in jail in Warren County, we'll try to get her on this afternoon, okay?
Thank you, sir.
All right. That's Mr. Logan. All right. All right, let's move on then to the Barron County Detention Center. We've got several. Josh Bradley. There should be two, Jim.
That's my case, Judge.
I'm thinking that this is going to be a request to set a, is that right?
That's correct.
Okay. Is there a motion filed yet? It's not in the record if there is.
I believe I filed one last week.
Let me back up.
There's two different cases.
Oh, okay, I see it. It actually got in the file before the violation reports got in there, so that's why I didn't see it. I thought it would be the other way around, but. All right. So we can put this on for a hearing next Tuesday, which is the 8th, 9th, February 9th. Mr. Berry, I believe I'm probably going to need to appoint counsel here. Mr. Bradley, I think, had counsel when his case was originally in court before he went to probation. But if memory serves, it might have been Mr. Spears.
That's fine, Judge.
Okay. All right. So February 9th at 1:30.
Okay.
So we've got Butler County on here now. So I believe.
Judge.
Oh, not a problem. We got plenty to do. We're just taking it as they come. We've got Ms. Parks in Butler County. So
There she is, Judge.
thank you. This case is on here because of an alleged violation of pretrial diversion. The Commonwealth has filed a motion to void pretrial diversion that was filed back in September. It looks like Ms. Parks was brought into custody in January. So as far as I can tell, we're going to need to schedule a hearing for this. And subject to what they tell us over there at the Butler County Jail about availability, that hearing will be next Tuesday unless they can't do it. And then we'll work around them.
Sorry, I do have an attorney, Jason Hayes. My mom's gonna go pay him today, so he'll be there with me on Tuesday too.
Okay. So can they hear me there at Butler County? Is there any reason Tuesday afternoon won't work about 1:30?
As far as I know, it should work.
Okay. We'll send you a link, and if there's a problem, just please get back with us, okay?
Thursday at 1:30. Ricky wanted to know Tuesday.
No, Tuesday.
Okay, Ricky wanted to know if she was gonna get a bond reduction or anything,
Not before Tuesday,
not before Tuesday. Okay.
okay?
I'm going to Simpson County.
That's the 9th of February at 1:30, okay?
All right.
Thank you. All right. I believe that's it for Butler County. Andrew Connors. She said Jason Hayes. I mean, he's not ever represented her in this case, but that's what she.
What's going on?
Hello, Mr. Connors.
What's up?
Well, the Commonwealth has filed a motion to revoke your probation.
Oh, no, man.
Yeah, I know. And they want a hearing on it. So we're gonna have to set that. It'll be next Tuesday.
Next Tuesday,
You betcha.
1:30.
You bet.
All right.
Do I need to appoint an attorney to represent you?
Yeah, yep. I'm trying to have Mr. Barry.
That's fine, Judge.
All right, Mr. Berry. We'll see you on Tuesday, okay?
All right.
Thank you. Oh, okay. Mr. Hampton, are you on here for Kelly?
I am, Judge.
All right. Kelly Kearney?
Judge, we still have a hearing set March the 9th, I think, on the original motion, so.
Well, if we want to accelerate that up to next Tuesday, we can. If he wants to leave it on March 9th, he can.
Yeah.
I'm not too picky, but I think given that this, we've had a new incident here,
Yeah.
we might need to go ahead and move it up.
Only thing is, I have an adjudication in family court starting at 1. That's a pretty serious matter. Looks like it's gonna happen at least right now, for sure.
Okay.
So that would mess me up Tuesday afternoon.
Yeah. Do you want me to leave it on and see if you get done with that and can join in? And if you can't, we can come up with a different plan, or how do you want to handle it?
You can do that, but I mean, I'm confident if that does not somehow resolve, we've got doctors at Vanderbilt and doctor in Louisville, and so I'm sure it's going to take longer than an hour if it does not otherwise somehow resolve, and it doesn't look like it's going to. You never know. I never give up hope.
I understand. Well, my guess is that we will be on for the entire afternoon. Typically those revocations are, we start them at 1:30 and we end up, doing them till 4:30 or so. So,
Oh, okay.
and if something happens and you can't get in because you can't get done with your other thing, you can probably send me or Miss Gardner. I think it's Miss Gardner's case. You can send somebody a text message and we can come up with a plan. Okay.
Okay. That'd be fine.
I don't want to put it off. If we can get to it, we probably need to get to it because he's going to be in custody.
Right. Yes, sir. I agree.
All right, Kelly, we'll probably see you. We'll probably see you Tuesday. Okay.
Thank you.
I mean, let's leave it on, I guess, but if we take care of it, we need to get it off. Yeah. All right. Danielle Cowan. All right. Ms. Cowan, you're here today because I believe this is on for an arraignment, but I'm not sure.
They both are on for arraignment, Judge.
Say again?
I'm saying these are my cases. They are on for arraignment.
Oh, okay. Fair enough. All right. Ms. Cowan, you've got two indictments here that I need to discuss with you. The first one is 21 CR 07. Grand jury in that case issued an indictment saying that on or about October 1st, 2020 in Berrien County, you knowingly and unlawfully possessed methamphetamine constituting the offense of possession of a controlled substance, first degree, first offense. That is a Class D felony. And that at that same time, you were in possession of drug paraphernalia, which is a Class A misdemeanor. In indictment 21 CR 027, grand jury has issued that indictment alleging that on December 26th, 2020 in Berrien County, Kentucky, the defendant knowingly and unlawfully possessed less than 2 grams of methamphetamine with the intent to sell, distribute, or transfer it, constituting trafficking in a controlled substance, first degree, less than 2 grams. That is a Class D felony. The grand jury also alleges that at that same time and place, you were in possession of drug paraphernalia, that you were operating a motor vehicle and failed to obey a traffic device, and that you operated a motor vehicle and changed lanes or turned off the highway without giving the appropriate signal. Those are traffic violations. Ms. Cowan, you have the right to remain silent. You have the right to an attorney. If you need an attorney appointed, I will take care of that here today. You have the right to a trial by jury where the Commonwealth has the burden to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine those who give evidence against you and to have the assistance of an attorney in doing so. You also have the right to put evidence on in your own defense. Finally, you have the right to appeal the outcome of your case to a higher court. Do you understand your rights?
Yes, sir.
Do I need to appoint an attorney for you?
Yes.
Judge, that'll be Josh.
All right. Mr. Spears, I'm going to note here that counsel is being appointed and we will enter a not guilty plea. We'll set ourselves a pretrial conference. I guess one of the things that's relevant is probably going to be her custody situation between now and then. She has a $1,500 cash bond on each of these. The primary reason being that she was out on bond in this possession case when she at least allegedly committed the actions that led to the trafficking case.
Judge, also wanted to note for the record, she also has a pending possession of heroin case out of Hart County as well.
All right. So anything that anybody would like to say?
Can these cases be run together between Hart County and here?
I'm not really sure what you're asking me. They're not, we can't handle the Hart County case here
Right.
because it's in Hart County. But ultimately if you do get sentenced on them, there may be some coordination of how your sentences go. It's premature to, I guess, for me to talk about that. That'll be up to all the lawyer types to, with. Her bond is $5,000. It says $25,000. It was $25,000 in district court, but on her indictment, I put $5,000. So, anywho, that's where we are. Mike, what's the deal with that Hart County case? There's been an indictment or no?
There has been an indictment, Judge, and she has a pretrial. I guess she's been arraigned already because she has a pretrial set for March the 19th.
Okay. Would it make sense to, I don't know, to do this before that, or?
I think so, Judge, because I'm going to talk to Mr. Spears about it, but the trafficking case is the main one I'm looking at. So if we end up resolving that, we can, I think it'd be better if we set it before her March 19th date. So if March the 1st is a Monday, and we can set it on that day, I'll get discovery out. That should give Mr. Spears enough time to talk to her.
That'll work. I'm agreeable with that.
All right, so here's what we'll do. I misspoke, Mr. Spears, the 21 CR 27, the trafficking, I said it was 1,500, it's 5,000 cash for that.
Okay.
It's 1,500 for the other one. But I don't think that's particularly, I mean, I think either one of those is a reasonable bond considering the charges. So you said March 1st is okay with you?
Yes, sir. I think that's on a Monday.
Yeah, it is. All right. 3/1 at 1:00 PM. Okay.
Yes, sir.
Thank you. All right. Ashley Nicole Davis. All right, Ms. Davis, you are here today for an arraignment on the basis of this indictment that came from the Barron County Grand Jury. Let me explain your rights to you. You have the right to remain silent. You have the right to be represented by an attorney. If you cannot afford an attorney, I can appoint one to represent you. You have the right to a trial by jury where the Commonwealth would have to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine the people that give evidence against you, the right to put evidence on in your own defense, and the right to appeal. Ms. Davis, do you understand your rights? Do I need to appoint an attorney to represent you?
Yes.
All right, the grand jury in this case, Mr. Berry, we will appoint someone from the DPA to represent Ms. Davis. The grand jury in this case has issued an indictment charging that on September 22nd, 2020 in Barron County, you knowingly and unlawfully possess methamphetamine. That's possession of a controlled substance, first degree, first offense, a Class D felony. Grand jury also alleged that on that same date and time, you committed the offense of theft of identity of another when you knowingly used or possessed current or former identifying information of another person with the intent to represent that you were the other person for the purpose of avoiding detection. The grand jury also alleges that at that same time and place, you were operating a motor vehicle knowing that your license to do so had been suspended, revoked, or canceled, or otherwise withdrawn, and that you were operating a motor vehicle in a careless manner without due regard for the safety and convenience of pedestrians and others using the roadway. Do you understand what you've been charged with?
Or can I ask, is there any way that I can go to rehab?
That is probably not an unrealistic thing for you to be asking.
Judge, if I could interject, if that's something that she would be interested in due to the nature of the charges, I would say that probably would be the basis of any offer that I made in the case. If DPA is going to be appointed, if they want to have Bethany talk to her and see if they can find something available for her for some inpatient treatment.
That'd be fine. We'll do that. And also Ms. Myers will be representing her as far as her attorney,
Okay.
but we'll make sure Bethany gets this also.
Is it just my imagination, or is there a Metcalfe County case that she's got too?
I don't see one. She's had a couple. There was a felony case. Let me see if it's still pending, but it was a fugitive warrant.
Okay.
And that's been raised, I think, a couple times and nothing seems to have happened with it.
All right. Understand. So, Ms. Davis, here's what we're going to do. I'm going to appoint an attorney to represent you. It's Miss Myers. You might be able to see her picture on there. She's going to come speak to you at some point. All right. She will also, in all likelihood, they have a social worker that can come talk to you about what your needs and maybe other issues that you might have had substance wise, and, you know, try to come up with some kind of proposal along the lines of what you're suggesting. Okay. All right. In the meantime, let's set this for a pretrial conference. I think under the circumstances, you know, it might be, you know, reasonable to just set this a couple of maybe 2-3 weeks down the road. I'm looking at, let's see, 8th, 15th.
I think 2 weeks would be fine as far as I'm concerned. We should get the discovery out this week and the offer.
Yeah. So Ms. Myers, what would you, 15th or 22nd, what works better for you?
15th will work, Your Honor.
15th? Okay.
Judge, you may have already addressed this and I just missed it. Has her bond been brought up, what it is and whether or not she's eligible for any kind of release?
Her bond was 1,500 cash, Mr. Berry.
Okay.
And let's see, you have her file? I'll grab that back real quick.
I don't know what kind of risk assessment she has or.
Yeah, I believe the big kicker for why there is a cash bond is because she got cited originally when she picked up this charge. It was back during kind of a no arrest period, and she did not appear in court until in district court they had to issue a warrant on her for failure to appear. And so, you know, I know those risk numbers are, you know, I don't know what they are in this particular case, but I know generally in one case, if you've already had a failure to appear in that case, it makes it a little bit, it gives you a heightened risk. So why she was already in custody when she got indicted, still on that basis. And I left her bond, you know, at a cash bond.
Okay.
Your Honor, I'm showing she is a moderate to reoffend and, like you just said, a high in the FTA category.
Okay.
Okay.
We can always revisit that later if things don't work out the way we think they might, but I believe that we've got a willing, a person that's asking for some help here, so we'll try to make that happen. Okay?
Thank you.
Thank you. Thomas Dobson. After we get done with Mr. Dobson, let me point out to you, I think too, Kenton County just got in. They've got one individual there, so we'll move over and take care of them as soon as I finish with Mr. Dobson here. Mr. Dobson is here because he was on, has been on bond throughout this time. We've had a lot of different issues on bond. This last one was a violation report from U-Turn for 2 no-shows. I think we probably need to go ahead and schedule a hearing to deal with that, so we can do next Tuesday.
Your Honor, there's also an arraignment in a new case.
Okay. Yeah, that's in the wrong case. All right, Mr. Gardner, hold the phone. Let me find that one.
It's the 21 CR 23.
All right, Mr. Dobson, you're here today in addition to that bond issue because you were indicted back in, I believe it was September, for possession of a controlled substance first degree, and possession of drug paraphernalia. The indictment reads that on or about February 29th, 2020 in Berrien County, you knowingly and unlawfully possessed methamphetamine and used or possessed with the intent to use drug paraphernalia. Those are respectively a Class D felony and a Class A misdemeanor. You have the right to remain silent. You have the right to be represented by counsel. I will appoint counsel to represent you. You have the right to a trial by jury where the Commonwealth has the burden to prove guilt beyond a reasonable doubt. You have the right to the assistance of counsel in confronting and cross-examining anybody that gives evidence against you, as well as presenting any evidence that there may be in your own defense. You also have the right to appeal. Mr. Dobson, do you understand those rights?
Where's my camera?
I'm sorry?
Yes, sir, I do.
All right.
Now, Steve, on that, what you just got to talk about,
Hold on. In 20 CR 279, I'm appointing counsel and entering a plea of not guilty on your behalf.
Here, just come here.
All right. So I'm not going to, I mean, you got the right to remain silent. So, you know, it's important enough they stick it in the Constitution. So I'll leave it up to you.
on the possession case you got to talking about, I was scheduled to go back to court on that in March. March the 8th, I believe. I'm not for sure.
Okay.
And I was just wondering why they was born out for that when I haven't even been to court for it yet.
Well, I'm pretty sure I told you. Because the Commonwealth filed a motion to revoke your bond because U-Turn said that you were violating your bond conditions.
Well, I'm not sure if it was or not, because I've not heard from U-Turn since back last year. I'm not sure if it's because of the COVID thing or what. But
Well, here's the situation. You have, I think, Mr. Spears, bless you, been representing you. So we'll make sure that you have representation. And the Commonwealth has filed a motion, so they want me to schedule that for a hearing, which I will do on Tuesday, the 9th day of February at 1:30, and we'll hear what everybody has to say about it, okay?
yes, sir.
And you'll be saying the same thing.
Thank you.
I'll be able to talk to you.
Will I be getting out today?
No, sir.
Okay, thank you.
Thank you. Mr. Cunningham, is that you up there in Kenton County? Very good.
This is Kenton County. Can you hear us okay, sir?
I sure can. Thank you.
Yes, it's me, Judge Alexander.
Mr. Cunningham, how are you?
I'm doing good.
All right. You're here today.
It's a motion to revoke bond I filed back in June.
I got you. Let's see here. Yeah, I guess, Mr. Spears, this one was you back when, I mean, it's been a while since we've been in court on it, but I believe it was you.
It was, Your Honor.
Are you, let's see, I suppose we need to schedule a hearing on this motion that the Commonwealth has filed. I don't know if that gentleman that's with you there, Mr. Cunningham, can tell me, we normally file these, or we normally have these on Tuesdays. The next time we would be having a revocation hearing would be Tuesday, the 9th of February. I don't know how that intersects with what other things they're going to need the room for up there in Kenton County. So if that ain't going to work, we'll try to come up with a different time.
Say what time?
It would be in the afternoon, which of course you're on Eastern time, right? So about 1:30 our time, which would be around 2:30 for you.
All right, 2:30, we usually have one court. We have two courtrooms, and we usually do have one court at 2:30, so we might be able to get him in if you wish to coordinate that.
Okay, why don't we go ahead and shoot for that? I'll enter that, and my staff will be in touch with your guys up there about, okay?
Okay, what date would you like? I'll give them a warning that you're going to be contacting them. What date?
Yes, sir. That's Tuesday, the 9th, a week from tomorrow.
And what time you think our time?
Yeah, 2:30 for you.
At 14:30 our time.
Yes, sir.
All right, I'll give them a warning.
And let me tell you, sir, if you are going to be warning somebody, you know, that's a docket. So there'll be a bunch of cases on, and if you can't get on at 2:30, but you could get on at 3:30, we'll still be going.
All right, thank you.
Okay.
All right, may I request that Mr. Spears do a video visit or make contact with me or something?
I will Estill. It's just a matter of trying to get it coordinated, but I will do it.
All right, thank you.
All right, thank you.
Is that all you need from us, sir?
You bet. Thanks for your help.
Thank you.
I think I only gave you 2 at Thomas Dobson's back instead of 3. All right. Caseyon Dugan. All right. Mr. Dugan, you are here because, am I saying your name right?
Yeah.
All right. You are here because you have been indicted by a grand jury on the following charges: strangulation first degree, a Class C felony; wanton endangerment first degree, a Class D felony; fourth degree assault, domestic violence, a Class A misdemeanor; menacing, a Class B misdemeanor. The indictment reads that on or about 25 November 2020 in Barron County, you committed the offense of strangulation when, without consent, you intentionally impeded the normal breathing or circulation of the blood of Sierra Owsley by applying pressure to her throat or neck or blocking her nose or mouth. Strangulation in the first degree is a Class C felony. The grand jury goes on to say that at that same time and place, you committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, you wantonly engaged in conduct which created a substantial danger of death or serious physical injury to multiple police officers. 1, 2, 3, 4, 5, 6. The grand jury also alleges that at that same time and place, you committed the offense of assault fourth degree domestic violence when you intentionally or wantonly caused physical injury to Sierra Owsley, and you were in a qualifying relationship that makes that domestic violence, meaning that you were either married, related within the second degree, currently or formerly living together, or have a child in common. Count 4, the allegation is that you committed the offense of menacing at November 25th, 2020 in Barron County when you intentionally placed another person in reasonable apprehension of imminent physical injury. Mr. Dugan, you have the right to remain silent. You do not have to say anything other than answering these basic questions that I'm asking, that I will be asking. You have the right to an attorney, and if you cannot afford an attorney, I can appoint one for you. You have the right to a trial by jury where the Commonwealth has to produce proof beyond a reasonable doubt. You have the right to confront and cross-examine the people that testify against you, and the right to put evidence on in your own defense. You have the right to appeal. Do you understand those rights?
Yeah.
All right.
Am I gonna get mental help?
I'm sorry?
Am I gonna get mental help or not?
Are you going to get,
I'm going to prison. Where am I going? What's happening?
Well, right now, it is, I'm just telling you that you've been indicted. This is,
Charges I didn't do.
this is not the end of your case. This is, just the beginning of your case from the standpoint of being in this, in circuit court. So I don't know what the ultimate outcome is going to be if that's what you're asking me. However, based upon what you are asking me, Mr. Berry, I can probably need to appoint counsel. And if you feel like, or if anybody feels like that maybe I should seek an evaluation and treatment at KCPC, I can go ahead and enter that and not, have any more delay. But, he seems to be, he says something about needing mental health treatment. And of course, I'm not familiar with anything that's happened up to now. So,
Right. Judge, Ms. Myers would be taking this case. I don't know. She would probably want to talk with him before reaching that kind of decision.
Yeah, I would like to meet with him first, Your Honor, if that's okay with the court.
it is okay. Listen, I don't have to have a request to do it, but I also, would think that more information is usually better than less. So I'm happy to have you meet with him first. But I guess where I'm going with that is, if you decide after talking to him that might be fruitful, if you just want to email me and copy whoever the Commonwealth is on it, but I could go ahead and enter that order. We don't have to have another hearing to enter a KCPC order if that's what we decide to do. Okay.
Thank you, Your Honor.
Judge, this is my case.
All right. So, Ms. Gardner, I'm going to go ahead then and enter a not guilty plea and order appointing counsel. We'll put this on for a pretrial conference just in case, there's some discussion that needs to be had or whatever. I'm going to put it on for February the 22nd. If something happens and that ends up being premature and you all don't want to do it, then we'll do an agreed order or whatever to move that. But I don't want to let it just sit there forever. I want to put it on fairly quick just so that we can go ahead and start moving in whichever direction we feel like we need to. Mr. Dugan, there will be an attorney coming down to speak with you, okay? And that'll be February 22nd at 1 o'clock. There'll be an attorney that's coming to speak with you, and it'll be Miss Myers. So, she's there to try to give you all the help she can give you. Be cooperative with her, okay?
Okay.
All right, thank you. Paul H. Gass.
Judge, on Mr. Gass, I'd filed a motion to revoke his probation. We could set a hearing date.
I would say that Tuesday, the 9th is going to be our best bet.
It's fine.
Mr. Berry, do you know who will get this one?
I think I've had Mr. Gass's case, if I'm not mistaken, Judge. Yeah, just put me down for it.
I'm pretty sure it was yours, Greg.
Okay.
Pretty sure.
All right, so February 9th at 1:30, Mr. Gass, okay? All right, thank you. In the 20 CR 230, that's a bond revocation, and the other one is probation revocation. We'll put them both on. I don't believe they filed a motion in the bond case, but. All right. Timothy Guess.
This is mine, Judge. This is set for arraignment.
Okay. All right, Mr. Guess, you've been indicted by a grand jury in Berrien County on the basis of the following allegations: Count one, on or about December 10th, 2020 in Barron County, Kentucky, the defendant committed the offense of receiving stolen property 500 or more, less than 10,000, when he received, retained, or disposed of the movable property of another, namely a 2005 Dodge Dakota belonging to Sean Wilson. It was valued at $500 or more, but less than $10,000, and he knew it had been stolen or had reason to believe that it had been stolen. That is a Class D felony. Count two, at the same time and place, the defendant knowingly and unlawfully possessed methamphetamine, a Class D felony. Count three, the grand jury charges that at the same time and place, the defendant committed the offense of wanton endangerment, first degree, when under circumstances manifesting extreme indifference to the value of human life, he wantonly engaged in conduct creating a substantial danger of death or serious physical injury to Barron County Sheriff's Deputy Brian Crane. Count four, criminal mischief in the first degree, on or about December 10th, 2020 in Barron County, Kentucky. The defendant, having no right to do so or reasonable ground to believe that he had a right to do so, intentionally or wantonly defaced, destroyed, or damaged property, namely two cruisers belonging to the Barron County Sheriff's Office, causing a loss of $1,000 or more. Criminal mischief in the first degree is a Class D felony. Count five is another criminal mischief in the first degree with respect to an allegation of intentionally or wantonly defacing, destroying, or damaging the 2006 Dodge Dakota belonging to Sean Wilson, causing damage of $1,000 or more. Count six, fleeing or evading in the first degree, on or about December 10th, 2020 in Barron County. The defendant was operating a motor vehicle with the intent to elude or flee and knowingly or wantonly disobeyed a direction to stop his motor vehicle given by a police officer. By so doing, created a substantial risk of serious physical injury or death to any person or serious property damage. Count seven, operating on suspended license. The allegation is that at the same time and place you were operating a motor vehicle knowing your license had been suspended. Count eight, theft under 500. At the same time and place you the allegation is you unlawfully took or exercised control over a license plate and fuel tank belonging to another person, valued at less than $500 with the intent to deprive the lawful owner. Count nine, possession of an alcohol beverage container in a motor vehicle. The allegation is on December 10th in Barron County, you had in your possession an open alcoholic beverage container in the passenger area of a vehicle located on a public road. And count 10, persistent felony or offender in the first degree, that you are over 21 years of age, you were older than 18 years of age when the underlying offense was committed, and you have been previously convicted in Hart Circuit Court, 18 CR 080, receiving stolen property under $10,000, sentenced to 3 years. Jefferson Circuit Court, 15 CR 649, wanton endangerment first degree, fleeing or evading first degree, sentenced to 5 years. And Barron Circuit Court, 12 CR 11, fleeing or evading first degree, wanton endangerment first degree, operating on a DUI suspended license second offense, and reckless driving, sentenced to 3 years. That allegation is persistent felony offender in the first degree. Do you understand what you've been charged with?
Yes, sir.
All right. Mr. Guest, you've got the right to remain silent. You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You have the right to be represented by an attorney. You have the right to confront and cross-examine anybody that gives evidence against you at trial, as well as the right to put evidence on in your own defense. And you have the right to appeal. Do you understand your rights?
Yes, sir.
Do you need me to appoint an attorney for you?
That's what I was gonna say. First I want to apologize for my last court appearance when I got kicked out. And I just really want to tell you I'm sorry for real, John. And can we put this off till May with I've got pending indictments coming. So can we just push this court date off till May? Maybe Josh Spears is already representing me. So see what I'm saying? Maybe we can get them all on the same court date. I've still got more coming.
Judge, he has one pending case that we are going to submit to grand jury, and a lot of it, the type of charge depends on the prognosis of the victim mainly, which we're still looking at. But I've talked to Mr. Spears last week about trying to talk about these cases again. We got 2 of his cases set for trial in May. I'd like to put a pre-trial on for March the 1st. By then, he should be hopefully indicted in the other case, and see if we can try to resolve these.
Well,
Excuse me, I'm sorry.
well, the thing is, you know, you couldn't try all of them together because you can't try a bunch of different things that happened, you know, years apart or allegedly happened years apart together. So, I mean, they ultimately might all get resolved together in some way, but I can't just like set these things off to be tried at the same time as your other cases.
No, that's not what I'm asking for, Judge.
No, I'm talking to him. I know, you know that. I'm explaining that to him. So I think it would be appropriate to set a pretrial prior to that May date, whether it's March 1st or something later, because of the very fact that, Mr. Guest, that you brought up, that there may actually be yet another case that comes down the pipeline, and you might as well kind of get everything all kind of in the same area to be talked about at once. And then maybe, you know, maybe there's something, maybe not. Who knows?
I was thinking maybe we could possibly avoid the trial dates if we get all these together and if he'd shoot me a reasonable offer.
Well, and that's similar to what Mr. Richardson is saying. It's just that since we already have those set, we might as well leave them on. We put this on March 1st. Theoretically, if there's an indictment before then, we can also arraign you on March 1st at the same time. And that way we'll have everything up here in one place. And, you know, that's when the work starts. Okay.
Okay. Can Josh Spears hear me? Is he?
Yeah, I can hear you. I'm gonna be up here. I'll be up here this week to see you.
Have you got my letters?
I have to go look. It's the mail's behind, so I have to go look.
I need copies of my motion of discovery. I mean, it's crucial.
We'll get them. We'll get them.
All of them. Thank you, sir.
All right.
All right.
Terry Huddleston.
Did you say Mr. Lunsford?
No, I didn't. Not yet.
Oh, I apologize.
No problem. Right now, we're going to talk to Mr. Huddleston.
Good, boss.
How you doing, Mr. Huddleston?
I've seen better days.
Yeah, I believe you. Hey, look, you got 2 different cases here we got to talk about, okay?
Yeah, I waived reading.
You waive a reading?
Straight to the meat, yeah. Waive the reading, get straight to the meat.
All right. Good, because to be honest with you, it's going to save me about 15 minutes.
I figured that.
Yeah. Do you want me to explain your rights to you?
Well, I know my rights.
All right. Then I'm going to appoint counsel for you, Mr. Huddleston. And we're going to go ahead and schedule a pretrial conference. I'll enter a not guilty plea on your behalf here. Do you happen to know when, I know you've got a, one of those,
Casey law hearings.
yeah, one of those, I couldn't
He
remember.
was waiting for somebody in Frankfurt or something, waiting for the dude in Frankfurt.
So is there a hearing scheduled or do you know?
Yeah, they rescheduled it. I don't know when, but they rescheduled it last week or the end of last week.
Who filed, Rita filed that?
Yeah, Rita did.
All right. All right. Well, why don't we put, Mr. Gardner, are you doing this one?
This is my case, Your Honor. Yeah.
Yeah. Well, the reason I'm bringing it up is because there is a pending Casey's Law petition. I was thinking that there'd already been a hearing on it, but there may also be another one scheduled. I believe that there's some challenges to the constitutional challenges that the district judge is going to have to address. You know, I don't want to wait on that So I figure let's go ahead and set this for a conference. And, you know, if something happens in between there that we have to put it off, we'll put it off. But I don't want to, you know,
It was something to do with the Attorney General up there.
right. Yeah, I think the last thing that happened was there was a motion filed, but the Attorney General wasn't notified, and that has to be done. So that was the rest of the, you know, that's what the weight is right now. So in any event, why don't we set this for a pretrial conference in March? I don't have a problem with March 1st if you all can live with that. Greg, I don't know which one of you is going to end up with this one. You know, there's, let's see, the 21 CR 18, there's 17 counts, but they're not all felonies.
Okay.
I think there's 4 felonies at PFO, and then the rest are misdemeanors. And then 21 CR 24, you got a couple of felonies, a misdemeanor, and a PFO.
Okay. I'll do that one, Judge. Who filed this Casey's Law petition?
His sister.
Oh, okay. All right.
And I think your office represents him on that, but I'm not sure who it is.
Ms. Hill.
Miss Hill.
Okay.
Is my understanding correct that somebody is then on his behalf challenged the constitutionality of the Casey Law?
Yeah, Miss Hill has.
Okay.
And what happened was she filed apparently a motion or whatever the case may be. And then when it came time to the hearing, the district judge noticed that as required by statute, the Attorney General had not been noticed on the motion or petition. So I think he's put it off. The only reason I know this is because he said something to me about it after it, you know, but he has rescheduled it to give her, you know, like to show cause or to show proof that she's notified the Attorney General before they proceed with having any hearing on it.
Right.
All right. So, Mr. Huddleston, let's look at March 1st at 1 o'clock. Okay.
10-4.
All right. We'll see you then. Probably. Crystal Gent.
That's mine, Your Honor. I think we're on for arraignments.
All right,
We would acknowledge receipt of the charges, waive formal reading here, plea not guilty, Your Honor.
How does this, we're going to go ahead and do a not guilty plea on both of these cases, correct?
Yes. I understand, you know, I need to get with Ms. Gardner. I think we've got a tentative agreement in these cases, but I don't think we can follow through to these. Well, I guess we don't have to enter a plea in these, do we, to get her sent, as long as they're put out?
No, we don't have any kind of resolution to these cases. I think what we have agreed is that in her drug court case that she's going to get a treatment, and then we're going to put the pretrial in these cases out at least 6 months in order for her to go to KRC.
Right.
Right. I remember us kind of going over this the last time that we wanted to, or the Commonwealth wanted to see how all that went in the older case before any kind of resolution was reached in this case, which makes sense.
Yes, sure.
So, Ms. Gent, I'm going to note here that you are represented by Mr. Bell. You waived a formal arraignment. We'll put you down for a not guilty plea. We're going to set the pretrial conference off 6 months or so, a little bit after 6 months, which right now would put us maybe towards the middle or end of August. Oh, we'll do August, let's call it the 23rd.
I I talked to pretrial, and they was talking about something that she said about reducing my bond down to surety bond.
Yeah, here's what, are we gonna do, are you all gonna do, this is just me needing a refresher. Are you all gonna do some kind of order in that other case that, or did we already address it and we're just waiting for a bed and then I need to change the bond in this case to make it happen?
It was my understanding that Candy was going to arrange for the treatment. I can text her and double check on where that stands.
Didn't she say that she needed to get this arraignment out of the way first before she could
Yes,
put her on the
before
list,
she,
but-
yes.
That's
And I'll
right.
text her now and let her know.
All right.
Yeah.
So I'll probably just, Johnny, I'll probably just have to wait until Candy gets the bed date and then sends me an order.
I had talked to her and she advised me that she couldn't do anything till the arrangements were done today, but then she should be able to have Miss Gent a bed in less than, approximately 2 weeks. As
Righto.
long as we're
Sounds good.
leaving out. So that's the plan.
So what we're gonna do, Ms. Parker, is I'll here, let me write, I messed up, sorry. I better go ahead and write these bonds down, but she still got that hold in the case that she was on probation or pretrial diversion for, where she went to drug court. So but I'm just gonna go ahead and change these bonds now so that whenever that other thing manifests itself, she doesn't fail to get out because she hadn't made these bonds.
Yes, Your Honor.
You understand everything, don't you, Crystal?
Not really.
Well, we had to get these arraignments done before they could do any evaluation or assessment on you. Now that we've got those done, they should assess you this week. And hopefully we'll have you out of there I'm hoping by sometime next week, in the next 10 to 12 days, so whatever we can get worked out. But that's what I've been advised by Ms. Browning that we could get done.
Okay.
So I don't have that other case at my disposal right now, but the conditions of her bond in this case will be, your standard, maintain contact with your attorney, attend court when you're supposed to, right? No new offenses, no drugs and alcohol. And the unusual condition will be for her to comply with her court order in any other case, because she's going to get a court order in that other case that sends her to residential treatment.
Okay.
Yes, sir.
It just hadn't happened yet. All right, Ms. Gent, hang tight, okay?
All right, thanks.
I think that concludes my business, Judge. Y'all have a good day.
See you. Douglas Justice. All right, are you, let's see, Mr. Spears, are these?
Yeah, I have taken over his case from Mr. Scott, so,
Okay.
I'm curious to know why he's currently incarcerated, because I just spoke to him last week, so he was out of jail, so.
Yeah, well, because he was on bond with random drug screens at U-Turn and allegedly has not gone to a test since June, despite multiple calls. And then the big incident was in January, when Julie says that she talked to him a couple of different times and he just told her that he was not intending to come in for any drug tests. So.
John? Was that trying to say something?
You can if you would like to, Mr. Justice, but we're not going to have your hearing right now. We're going to have it next Tuesday.
Hearing for my bond?
Yes, sir.
Well, so I got I'm trying to explain to you. I have been sick. You see, out of the hospital. I was in an automobile accident the week before in Cave City. Michael Hill was the officer, and the automobile pulled out from me. I hit him. I hit him straight on. It wasn't my fault. A couple of days later, I went to the hospital. I was already at the urgent care, and they Anyway, I got surgery coming up. I got x-rays this week. Next week, I'm supposed to have a surgery for my hernia and breast x-rays for my back. So I've never gave it during urinalysis, ever. Not one time. I've been on it over 2 years. Is there? I mean, I'm clean. I've been clean. The doctor's orders, Dr. Combs, I think it was, she told me, she posted sent Joshua Spear something about the documentation saying that I couldn't go into the U-turn program because I could be liable if I get anybody sick, and specifically to follow doctor's orders. Sir, Your Honor, if Judy and them let me come back, I don't care how sick I am or how hurt I am, doctor's orders, I'll come in to U-turn. I promise you my words, Your Honor, you know, just like I've not ever not came to a court date or nothing without documentation, and I've seen documentation there. I've been sick for a long time. I'm not in good health. I got still, okay. Is there?
Mr. Spears, all I'm going to tell you is that when Miss Atkins called and told me about this, I told her that I knew he had some health problems, and she called the doctor herself, according to what she told me, and said he has said that you told him not to come in and take any drug tests, and she said there is nothing about his condition that he can't come in and take a drug test. At which point, Miss Atkins says she got back in touch with Mr. Justice and told him that, and he said, I'm not coming in to take a drug test.
No, sir, that's not what I said.
You can tell me all day long that you are clean, but I mean, when you get the chance to go in and take a drug test and you don't do it, then
Yes,
that
sir.
takes more than what you're telling me now.
Well, Supervisor, sir, Your Honor, can I say something?
No, we're going to set it for a hearing and we'll hear what she says, and maybe she's not telling me the truth, but we'll find out.
Judy's telling you the truth, sir. Judy's telling you the truth, but I don't know which doctor she got her with. Was that the urgent care?
She talked to Dr. Combs Royce.
And is that the
Wrote
urgent?
you the note.
And she told me when she left the room in urgent care, not to go anywhere because I could be liable to go home and quarantine until negative results. I
mean, I don't know what.
I've had surgeries going on, so I got back, my nerves in my back, my vertebrae and stuff. I'm supposed to have surgery coming up. I'm supposed to get my x-rays in this week. If I don't get the rest of my x-rays in and CAT scans, then they're just going to be gone for a couple more months. And I'm really hurting, sir.
I understand. I mean, you know, I don't know what to tell you, but you've been on bond, and she's been trying to call you since June to come in and take a drug test, and you hadn't come to take any of them.
Would you ask her? I've not been dirty. I mean, I was on parole at that time, reporting to parole also.
Hey, listen, let me interrupt you. We'll talk about whatever we need to talk about, but we're not going to talk about it till we have our hearing on Tuesday and all the people are sitting up at the table together. Okay?
That tomorrow?
Nope. It's a week from tomorrow.
Sorry.
Okay? All right.
Thank you.
Philip Brent Kirby.
Oh.
That's my case, Judge.
All right. This is Mr. Kirby and indictment.
Yeah, Your Honor, I can waive the reading of the indictment.
Okay.
If you'd like.
Do you want me to explain your charge or your rights to you?
No, I'm well aware of my rights, my Miranda rights, Your Honor.
All right, sir.
If I could at this time, I'd like to speak briefly. I had a court date with Judge Crocker out of Allen County on the 5 that I'm serving there. She agreed to drug court. I had an assessment done, which I was determined to be a candidate for drug court. Copy was sent to Judge John Grice in Warren County for him to approve a transfer up there, and she was going to rule on my drug or on my shock probation hearing out of Allen County. I was hoping at this time to have an unsecured bond, been incarcerated for 6 months already, and to drug treatment or drug court.
Your Honor, first of all, and looking at Mr. Kirby's record earlier in the morning and looking at probation and parole's website, it shows that he's an active inmate. So I don't know what good any kind of reduction in bond in this case would do when he's serving a sentence. Additionally, Mr. Kirby, these are not typically charges that I would consider drug court for or a probationary sentence. He's charged as being a persistent felony offender in the 1st degree. He has a long record. So I think the bond at where it's at is appropriately set. And I don't see that drug court would be part of any offer that I would make anytime soon. And I don't see that it ever would be part of an offer.
Well, it sounds like at the very least, what needs to happen is that I need to, Mr. Kirby, is make sure you have a counsel appointed, and, you know, you've got multiple courts here. You probably got a attorney in each one of these courts. So the whoever I appoint for you can talk to your lawyer in your Allen County case. Or did you say Allen or Simpson? Allen?
Yeah, Allen, Judge Crocker. I got 5 out of Allen County, 3 in Warren County that I'm currently serving.
Yeah.
Also, I would like to have a lawyer come speak with me and keep the option open for a rocket docket deal, just to move things through and to.
Yeah, I will appoint counsel for you today, and then I'm sure that they will try to get in there and talk to you as quickly as they can, you know.
Okay. Is the rocket docket open still, or how does that work?
Well, technically now that you've been indicted, that, you know, the rocket docket is something that might happen before you get indicted. So now, that being said, in reality, rocket docket really just means moving quick. So, if y'all got an agreement worked out and you wanted to move quick on it, I'm not going to stand in your way.
Okay.
Okay.
Thank you, Ron.
Let's set it for a pretrial conference on, just because he's got all these other things going on, and, I don't want to get in the way. Let's set it for February 22nd at 1:00. And, that way we'll try to get the ball rolling and see if there's some way to integrate everything that you've got happening. Okay.
What's my bond currently?
It's a 5,000.
Okay. And there's no way you would consider dropping it to maybe some type of surety bond or anything like that?
Oh, I would consider it, but what I think I need to know is what's going on in these other cases first, because right now, obviously if you get shocked out in Allen County, I'm likely to try to cooperate with that, so that, if all the other judges around here are interested in you getting out of custody, I'm likely to try to cooperate with that. But, right now I need somebody to prove that to me. Okay.
Yes, sir.
All right.
Thank you for your time.
Thank you.
That'll be my case, Judge.
All right, Mr. Perry. 222.
Is he being held in Barron or is he?
He's in Barron right now.
Yeah.
You're not, okay. All right.
Could you come see me soon, please?
Yeah.
All right.
Yep. He'll get you. Pamela Morris.
Hello, Your Honor.
Judge, that's my case. This is Ken Garrett.
Where the hell did you come from?
Out of the woodwork.
What?
Out of the woodwork.
Hey, Ken.
Hey, Pam.
How are you?
So he's doing that deceptive Zoom user. I don't know who he is.
Just lurking in the shadows, Judge.
Yeah. All right. Well, what this is about here, Mr. Garrett, is that Miss Morris was on bond, and there was my understanding is, I don't have anything in here, but my understanding is there was a new arrest for operating on a suspended license, and because that was part of what we were here on, this is a DUI third. I think I told him to hold her till we could see her today. I don't know what I don't have anything in here to prove what the charge was, but that's my memory. I don't know if there was a felony involved in it or just a misdemeanor.
I think they were just misdemeanors, Your Honor, but yeah, it was driving on a DUI suspended. And I think I filed a motion on that.
Oh,
There
okay.
was a
See,
file.
I have not seen that. I mean, it's not gotten in the file yet. That's why I was struggling, because I didn't know if you had filed a motion or not.
I believe that I have. Now, her name
Your
again is-
Honor, I'm showing it was 21T282,
Okay.
careless driving on DUI suspended license and failure to produce insurance card and displaying that fictitious license also.
Okay. Well, Mr. Gardner, I mean, if you have filed that motion, then, and you are wanting to have a hearing, then that's what we'll do.
Your Honor, can you remind me of her name again? I'm sorry.
Pamela
This
Morris.
is Pamela Morris, 20 CR 166.
I was going to try to pull up coordinate here and I filed several last week, and I can't remember if this is one. This is ringing a bell as far as the charges, what she was charged with, and what the new allegation was. So I think that I filed the motion. I was trying to double check.
Crystal says there's not one popping up in KY courts.
John, would you be willing to do a sanction of some sort?
I can consider that if we want to go ahead and set the hearing.
Could we do it tomorrow?
The sanction is probably going to be longer than that, Ken.
Okay.
Well, tomorrow's not a docket day.
Oh, okay. I got you.
I don't mind setting it, and then if you all want to talk about it between now and then, that'd be adequate.
Yes, please.
We'll do that, and if I haven't filed the motion, I will.
Okay.
And Pam, I'll be up there to see you today.
Okay. Your Honor, can I say one thing?
Yes.
He didn't ask me for my license. He asked me for my ID. He didn't, because he knew I didn't have a license. He just asked me for my ID.
Pam, we can, we'll talk about that and we'll get that squared away.
Okay.
Yeah.
But I will be up there shortly to see you.
Okay, Ken, thank you.
All right. Thank you.
Thank you, Judge. And that'll be for next Tuesday at 1:30.
You bet.
Thank you, Judge. John, I'll be in touch.
Okay, just send me an email or call me.
Okay, I'll do it. Thank you.
Brittany Paxson. It didn't occur to me until just now that Ms. Paxson has employed counsel in her other case, and I don't think I asked the clerk to send a copy of this indictment to him, so I'm sure he doesn't, or well, I'm not sure. I would think maybe he doesn't know that we're on. Because she is in custody for that other case anyway, my suggestion would be that we try to reschedule this arraignment for next Monday, and we send him a or some other communique so that he can try to be available. Normally, if I know you have an attorney in a case, I have a copy of the indictment sent, but since he was in a different case and not this case, it just slipped my mind. I don't think it'll materially change anything because her pretrial's not off or is off, for It's not today or anything. Does that sound objectionable to the Commonwealth? Or
That does not, Your Honor.
Ms. Paxson, we'll put you on next Monday and try to send a copy of this to Mr. Driver, get him in the mix, okay?
Okay, thank you.
Thank you. 10 o'clock. Danye Pipkin?
That's my case, Judge. I filed a motion to revoke probation. We could set a hearing.
Yeah, we can do it Tuesday if everybody's available.
That's fine. You mean the 9th?
I mean the 9th, yes, sir. Let's see, Mr. Barry, I'll need to re-up with somebody there in the DPA office. I can't recall who.
Okay. I may have had Danya.
I cannot recall who was with him the last time.
Josh has him.
Josh, okay. All right.
All right, so I believe there's did they file something in Monroe also?
Talking to me, sir?
Well, that was just kind of a general question. Do you know?
Yeah, I have a hearing on the 18th.
All right.
Yeah.
All right, fair enough. Thank you. Cody Rivera.
Those are both my cases, Judge. He's set for pretrial in one, but he's got an arraignment on a new indictment, 20 CR 20.
Wait, hold on. Do what?
I was wondering, did you get the completion letter of my treatment program? They had talked to your secretary, and they were supposed to be faxing a completion letter, and she said that she would put it in my file. Naya.
I don't know, but your probation officer should have it, shouldn't he?
Yeah, I think he does. But I thought, because I had her send one to you and to Judge Williams, and also to the state attorneys, to the county attorneys. And I just, haven't ever heard anything. I know I'm always hearing bad stuff, but I just kind of, there was a good letter, and I kind of, I haven't heard if anybody,
I have that, Judge. I have that letter.
Okay, I was going to say, we have a letter that was sent right before you got out, but I don't have anything that was sent after you got out.
Yeah, that's the letter I'm talking about.
But I know that you completed treatment back in
December.
December, wasn't it?
Yes, sir.
Yeah. I was aware of that either from Officer Bray or somehow.
Okay.
All right. Thank you.
All right.
Judge, Cody is Mr. Rivera is my case. There's, I believe, an arraignment this morning. He had a pretrial and an arraignment set for.
Right.
I was sort of the mind that these cases be put together in one pretrial day, 2 or 3 weeks down the road, and see if we can get something worked out on both of them.
Okay.
Follow me.
Mr. Barry, do you and Mr. Rivera want me to read his rights and charges to him, or do you want to waive a formal arraignment on that?
I'll leave that up to Cody. If you want to hear what you're charged with on this new case, Cody.
I had a new case that was a felony.
Do what?
What is the misdemeanors?
No, it's burglary 3rd degree, which is a Class D felony, and theft under 500, which is a Class A misdemeanor.
No, I'm
okay.
you don't have to read them.
Okay. Do you understand your rights, or do you want me to explain those to you?
I understand my rights.
All right. Thank you. Mr. Berry, let's do this. I'll appoint counsel in this new case, 21 CR 028. We will enter a not guilty plea on Mr. Rivera's behalf. We'll put him on for a pretrial conference, and we will move the 20 CR 99 pretrial conference to the same day. We'll put them on, you want to do February 22nd?
That's fine.
3 weeks? All right, so that way we'll get them kind of together where you all can try to talk about everything at once, okay?
And Your Honor, could I speak just for a second, please?
Yes.
I just want to apologize for wasting the time of the court and everything. And I was going to see if I could get maybe through U-turn, because I was on bond before, but I've never. I know I got a drug problem. If I had to go and take drug tests and everything else, that would give me a reason to stay clean and actually do good. So I talked to a U-turn woman about a month and a half ago, 2 months ago. And she told me if anything changed in your court, just have my people let her know. And I was going to see if that was a possibility.
Yeah, I mean, it might be a possibility. I think right now what we need to do is I've appointed Mr. Berry, so let him get into it, dig in a little bit with your case and talk to you about it. We'll come back in 3 weeks and we'll see where y'all are. And if you want to request some bond change at that point, you can do that. Okay.
Okay. So my bond's going to stay as the contempt.
Yeah, it's going to stay like that till we can get all this, so that everybody can get a look at what's going on here.
Okay.
Okay.
Yeah.
Fabian Sebastian. You are Mr. Sebastian, correct?
Yes, sir.
Mr. Sebastian, can you tell me your address, sir?
606 New Salem Road. That's my mom's house, but.
Okay. All right. Is your date of birth 1/28/1993?
Yes, sir.
Mr. Sebastian, do you want me to explain your rights to you, or do you want to waive a formal explanation of your rights?
No, sir. I understand.
All right. Do you want me to read your indictment to you, or do you want to waive a reading of your indictment?
Yeah, I understand.
Okay. I will. Let me just summarize by saying that your charges are trafficking in a controlled substance, first degree, 2 or more grams, first offense with a weapon enhancement. That's a Class B felony. Trafficking in marijuana under 8 ounces with a weapon enhancement is a D felony. And then possession of drug paraphernalia with a weapon possession enhancement is a D felony. I'm going to appoint counsel to represent you, okay?
Okay.
That'll be Miss Myers on this one, Judge.
Okay. Mr. Sebastian is going to enter a not guilty plea here today, so that will move us on to a pretrial conference. Mr. Sebastian, I'm appointing counsel, and we'll set you a pretrial conference for you want to say March 1st. It's a month. 3/1/2021 at 1 o'clock. It's customary at the arraignment to also take a look at the bond if you hadn't made bond. In this case, the bond was set at on your indictment at $10,000. That's largely due to the Class B nature of that one charge. I do not know if there's I don't know anything else about the history or anything like that. So Mr. Barry or Miss Myers, I guess I can take a look at all of those factors, after today and see if there's a model, unless you all know something that you want to say or bring to my attention. But there is I can look at the pretrial assessment and
I don't know, Judge, I've not looked at the assessment. Xanda's still working on cases from Elizabethtown. Every now and again, she has to run off up to there for some.
Understand, sure.
There she is. But I don't know what Mr. Sebastian's risk assessment shows.
Showing low on both categories, Greg.
I'm sorry, do what?
He's showing low in both categories.
Oh, okay. Yeah. Based on that, Judge, we'd ask the court to consider unsecuring his bond.
Yeah.
Judge, I was just gonna, if I could speak for a second, state on the record, it's a Class B felony with a weapon enhancement, guns and drugs. And obviously the low risk assessments, you're allowed to deviate from that if you feel that he's a danger to the community, which we do believe he is. I'm having trouble pulling up the case file on my computer. Otherwise I could go through some of the facts or the allegations, but we think he's a danger. We think the bond's more than appropriate.
Yeah, the best I can do is tell you that I will look at it and see. Obviously, if you're a low risk on those factors, then it's going to, merit another look. So I will do that, and Mr. Barry, I'll consider that that's a motion under advisement. In the meantime, we'll keep this pretrial for March 1st at 1 o'clock. Okay?
Okay.
All right. Thank you.
Your Honor. Your Honor, can I speak?
Yes.
Is there any way I could get 10%ed or OR?
Well, those are the things I'm going to consider. Okay. I just don't know yet. I need to look at some information.
All right.
All right.
Hey, you're on. I don't know if they can hear me. I don't know if they can hear me.
But I don't know because they were on. All right. Colin Wheat.
That's mine, Judge. I'd filed a motion to revoke Mr. Wheat's bond. I don't see Bruce on here. I know I sent him notice through CourtNet, or he should have gotten notice. But we just need to set a hearing date.
Okay. We can set that for Tuesday as well. Okay.
Sir.
Mr. Wheat, we'll get in touch with, we'll send a copy of this notice to your attorney, okay?
What is the notice exactly?
A notice that they have filed a motion to revoke your bond and we're scheduling a hearing for next Tuesday.
Okay, so what happens next? I mean, like,
You'll hunker down and wait till next Tuesday and we'll have a hearing.
all right. Miss Atkins was referring me to rehab at Christian Faith Academy.
Say again?
Miss Atkins from U-Turn, when she revoked my bond the other day, because I've been in here since last Thursday, or last Wednesday, last Thursday, either one. She was referring me to Christian Faith Academy on the other side of Bowling Green, Morgantown. Is that still an option?
Yeah, we can't talk about any of this till Tuesday when we have everybody here, okay?
All right.
Okay,
Thank you.
all right,
What time is it again?
1:30.
All right, thank you.
Vicky Wilburn.
Your Honor, this is the Commonwealth's motion to revoke bond for U-turn violations. We could have a hearing date on it.
Yep, we're gonna put this on for Tuesday also. 2/9/1:30.
And Your Honor, Pamela Morris, that motion was in my inbox this morning. I have since signed it and filed it with the court.
Okay. All right, fair enough. Ms. Wilburn, we'll see you on Tuesday.
Okay, may I say something, Your Honor?
Okay.
I know that when I went to U-turn, I was dirty. My mother, Julie can tell you that my mother, me and my mom doesn't have a relationship because of the drugs. But my mom, I talked to her yesterday and she said, as long as I was clean, I could come and stay with her. So I will be clean. You will not hear anything negative against me anymore.
All right, well, we'll consider those options on Tuesday, okay?
Thank you.
All right. Jacob Williams. Could he be that we've moved him and he didn't get it? Mr. Williams, you are here today because you have been indicted by the grand jury of Berrien County on the charges of receiving stolen property, $10,000 or more, speeding 26 or more over the limit, and careless driving. You have the right to remain silent. You do not have to say anything that can be used against you. You have the right to an attorney, and at your request, if you cannot afford an attorney, I will represent one for you. You have the right to a trial by jury where the Commonwealth has to prove guilt beyond a reasonable doubt. You have the right to confront and cross-examine the people that testify against you, and the right to put evidence on in your own defense. You also have the right to appeal. Do you understand those rights?
Yes, Your Honor.
All right. The allegation is that on July 28th, 2019, you committed the offense of receiving stolen property, $10,000 or more, when you received, retained, or disposed of a 2018 Ford Explorer belonging to a Michael Sherfy, which was valued at $10,000 or more, knowing that it had been stolen or having reason to believe that it had been stolen. That is a Class C felony. The grand jury also says at the same time that you were operating your motor vehicle on a public roadway at a speed limit of 96 miles per hour in a 70 mile per hour zone, being 26 miles per hour over the speed limit. Also, that you were driving your vehicle carelessly without any regard for the safety or convenience of others on the roadway. Do you understand what it is that you've been charged with?
Yes, Your Honor.
Okay. So, Mr. Williams, I will, do I need to appoint counsel for you?
Yeah, I need an attorney.
When did you get arrested?
August 23rd.
Where'd you get arrested?
I got arrested in Franklin County.
Where?
Franklin County, Columbus, Ohio.
Franklin County, Ohio. Okay.
Yes, sir.
So then would you get extradited back here or what?
Yes, sir.
Okay.
Judge, this will be Josh's.
All right. let me tell you, you on? I can't see you no more.
I'm here.
All right, well, let's do this. I'm appointing counsel. I'm going to put him down here for a not guilty plea, and let's set this for a pretrial conference. I'm willing to do, something pretty quick to see what happens. Since he got extradited, it's going to be tough to make any bond-related changes. He's got a $5,000 cash bond. So let me put this on for February the 22nd.
That'll work.
For you all to talk and see whether we can come up with anything on this, okay?
Okay.
All right. Thank you. Stoney Winchester.
Judge,
Yes, sir. Yes, sir.
Mine, if I'm not mistaken, and this is a motion to revoke. And Mr. Gardner had sent me an offer this morning on it. I've not had a chance to talk to Mr. Winchester yet, but I think if I just convey it right now, it might resolve everything.
All right.
Hey, Mr. Winchester, can you hear me okay?
Yes, sir.
There's a motion to revoke probation on you, and Mr. Gardner is offering to give you a 30-day sanction and give you credit for the days that you've already been in there. Would you be interested in accepting that?
Well, I mean, is that my only choice?
No, you have a hearing.
That'd be fine. Then. That'd be fine.
How long you been in there?
About 5 days.
Oh, okay. We need to have 25 to do, and then you'd be back out on probation. Is that what you want? Is that what you want to do?
That'd be fine.
Okay. Okay.
Mr. Berry, can you run it by me again?
Yes, sir. It's a motion to revoke probation, and Commonwealth's offering 30 days sanction credit for the time he's done already. And Mr. Winchester thinks he's done about 5 days.
Okay. I don't have, let's see. Yeah, I don't have a return on his warrant. I have a warrant, but I don't have a return, so I can't confirm when he got arrested.
It was last Thursday.
Okay. I mean, I'm not doubting you. I'm just saying I can't independently. I don't have anything to show it yet. It won't be too hard to find out.
He got booked in on the 28th, Judge.
Well, super. All right, Stoney. So you can do credit back to your arrest day and do a 30-day sanction, get out, report to your probation officer?
Yes, sir.
You got to report as soon as you get out, okay?
Yes, sir. I've always reported to them. I mean, I've called them, and they don't ever answer. I mean, I don't know what to do about that.
Well, this particular arrest is because they say that you did not report to them.
The last 3 or 4 months, all I've done is call them, have a call.
Right?
You know.
Well, look, I've got Officer Bray on here, I think. If he's still listening, I'm going to ask him to give you a phone number to call when you get out.
Yes.
I mean, y'all might, they might be, everybody might be meeting in person back, whenever that happens, but because it's going to be towards the end of this month,
We've not heard anything about when we're going to go back in person. He'll just need to call Officer Bennett. If he can't get him the first time, just tell him to call Has anybody got an ink pen? They can write this down.
I've got one, Wes. Go ahead.
Okay. Call 270-678-7443. That's the office number. Somebody will be there. We'll be able to get in touch with somebody. Now, we're closed on Fridays now too, so it'll be Monday through Thursdays the days we're open, 8 to 4:30.
All right, you got it, Mr. Winchester?
Yes, sir.
All right, hang in there.
Have a good day.
Scotty Weeks. Oh, wait a minute. It's that, that's what I have in this, but I have everything else is him. Mr. Wicks, you are here in case number 21 CR 22 with the allegation of robbery in the first degree, a Class B felony, criminal mischief in the first degree, a Class D felony, persistent felony offender. Do you want me to explain your rights to you?
No.
Do you want me to read your indictment to you for the allegations?
No.
You sure?
Yeah, no, I know. I get no. I don't know. If you want to.
No, I mean, it's your call, not mine. I don't have any desire to read them.
Don't matter to me.
I'm going to need to appoint an attorney for you, I'm going to guess, right?
Yeah.
All right. So, Mr. Wicks, I'll appoint counsel for you, and we will enter a not guilty plea for you. We'll set this for a pretrial conference that can, I believe I can get out into March a little bit on this one. So how about we do March 15th?
That'd be fine, Your Honor. Like Mr. Guess, he has a pending case as well that'll be presented to the grand jury this month.
Okay, we will, I'll appoint counsel, like I said, and we'll take a look at it on March 15th, okay?
All right.
All right, thank you.
Judge, that'll be Miss Myers on that one.
Okay. All right. Let's see, Bonnie, I might have a couple that I don't have on my list that, you got Mr. Furman in there?
Yeah, but Chris Larman.
Okay, is there anybody else besides him?
No, that's it, Judge.
All right,
Judge, this is sort of a bad thing's happened to my family, man. My brother got killed by his girlfriend.
I know what happened.
All right. Well, I mean, Judge, I was up there in that rehab, man. If I'd needed 38 days to finish.
I know.
With that being said, man, I would have probably finished in the top of my class because with the things that to do, I was taking a portals class, which allows 90 days off the end of your probation sentence. I'd have got 90 days to complete the program and only had 38 days left. You take it back 180 days and you add it up, that would put me off probation the month I got out. It took everything I had to walk out that door, man. But I called my family, man, and they were gonna give me a 2-hour furlough up there, man. Due to COVID, I wasn't gonna get to see my family, man. So I may have screwed up, man, but just coming home anyway. But I felt the place for me was my family, man. And I got out. I called my probation officer, done like I'm supposed to do. I had an anxiety attack yesterday, man, and
Judge, can I speak?
it scared my poor sister-in-law to death, man. Really.
Hold on. What's the Commonwealth wanting to do?
Judge, I talked to Officer Ford before I got on here, and I'm aware of what the situation was about him leaving treatment. There are other concerns that I have. I think there was an allegation that he had used while he was out. So I've got concerns.
Test me.
Mr. Thurman, I said it was allegations.
All right.
I'd like to see him go back to treatment. What I told Charity was I would like for her to update her reports I'm going to file a motion, but if he can go back to treatment and they are working to get him back there, I'd like to see that happen, but I was going to file a motion because I'm not saying he's going to do this. If he ends up leaving, I don't want to have to wait till then to do it. And if he goes back to treatment, and he completes it, you know, that's going to fare pretty well for him, but they are working to get him back, Judge, and that's what I'd like to see. But I also would like to see him stay in until it happens.
Can I say something?
Yes.
Look, Judge, all I want to do, man, is I don't know. I wasn't there when the funeral arrangements were made. They were going to bury my brother tomorrow, next day, man. All I'm asking for is just, if I can get out, man, till this funeral's over, I'll come report in wherever I've got it. I'll do whatever I got to do, man, because I feel I've come a long way, man. I've grown so much in that program, man. And I pushed it all away, man, by coming home, because they won't let me start that program over. Whatever I do, I got to do another 6 months. So be it, man. It was my choice that got me out. I just want to go be with my brother, man. Today, tomorrow. I feel like I'm gonna go back there right now, man. Just cover my head up and cry, man.
Well, I'm gonna have to talk to Charity about it. We all agreed on the same.
She hates on me for some reason.
She does not. We were gonna let you go back to treatment until the police called last night and said you were laying over dying. That's why I put you back in jail.
Well, I felt, honestly, Judge, I'm not allowed to give me a drug test, man. The lie, it's in the test. Man, I got sitting on the front porch talking about my brother, man, and started crying. And I ain't never had an anxiety attack in my life, man. And something come over me, and I thought I was dying, man. It scared my poor sister-in-law to death. She called a damn ambulance on me. You know what I'm saying? Give me a drug test, man. But I won't get back out and be with my people too. You know what I'm saying?
I know you do. Listen, let me talk.
This is killing me in here, man.
I know it is. Let me talk to her and see if I can figure something out. I don't know. I can't just let you break the rules neither.
Well, Judge, I didn't break no rules, man. Look, they get a little drug tests in here everywhere, man. Go get me one.
Well, I'm not down there, Chris.
Well, no, there's all kinds of people work for you. You know, there's all kinds of work for us. There's a little room right over here, man. I bet you that something's clean.
They don't work for me. They just work with me.
Well, they work with you. Let's work. I'll walk with them over here and get the drug test in. You know what I'm saying? It was an anxiety attack, Judge, man.
How long stop talking for a minute. Okay. How long we been doing this stuff, man? You and me.
Since I was 18-year-old, and I've never lied to you. I have the rest of them.
I'm trying to help you out here, but I can't.
I know that.
Like it ain't nothing. Just work with me here. All right.
I go from 0 to 60 so damn fast, man. I'm working on that too. You know what I'm saying?
I understand. Just let me talk to her and see, if I can come up with something.
I appreciate it, man. I don't want to look here, and honestly, just between me and you, I don't want I don't want nobody to take me and if y'all gonna take me shackle handcuffs and embarrass my family, I'll catch you on the next run. You know what I'm saying? Because
I don't want to embarrass you in front of your family.
I feel that's humiliation to come take me shackled in front of my family and me being in this town my whole life. You know what I'm saying? And y'all never had one on me for more than 3 days. You know when you get the point, you know where I'm at. You know what I'm saying?
Yeah.
If I make
this
shit, give me
work with me.
I'm trying to. I want you to work with me, bro.
I'm putting it on for Tuesday, and I'll see what I can do.
Well, they bury him tomorrow.
What did I just say to you?
You said Tuesday.
Right, next Tuesday. But I'll see what I can do in between there.
All right, thank you, Judge. And I'm sorry. I'm sorry to go from 0 to 60 like I do, man. I'm working on that, bro.
Where's his funeral at?
It's at the one at the outside Walmart.
Yeah.
At the funeral home. We're having I don't know, it's at a church somewhere, man, where we can review his body, and then we're having a graveside funeral. That's what I've heard. I ain't even got the call or nothing, man. You know, I don't know, man.
I know. All right.
You know what I'm saying?
Yep.
If you get me out today, just go be with my family, man.
Okay. Hang in there.
Thank you. I'm sorry. Look, Judge, I'm sorry to do that, man. You know what I'm saying?
Yeah. Find your center.
Some have been working on rehab, man. I go from 0 to 60 so fast. I got to tell myself to slow down. But then when you get me excited, man, it's just like, God dang, man. And being sober, man, has made it even worse.
The last thing I want to do is excite you.
Well, no, please. I mean, I just want to get back out my family. And look, I wouldn't use no drugs. Just honestly, I don't know the damn anxiety attack, and I had one that scared my poor sister-in-law to death. You know what I'm saying?
Hey, listen, the longer you keep me here listening to you, the less time I got to do something with you.
I'm out of here. Thank you.
Bonnie, is that it for the morning?
That's all I've got, Judge.
Oh, that was plenty. See you in a little while. All right.
Judge, I see Preston Pruitt, who is a Rocket Docket, is on here. He's not on the docket. I do know, looking at court note, he was to submit proof that he had enrolled in treatment by January 31st. So I don't know if that's why he's on.
Yeah, no, Crystal's been trying to figure out this whole time why he was on, because nothing in CourtNet showed that he was supposed to.
Yeah.
Yeah, he had.
Hi, can y'all hear me?
Yeah. All right. What you doing, Mr. Pruitt?
Hold on, y'all got real quiet. There we go. Can y'all hear me?
I can hear you.
All right. I guess I muted y'all or something.
Well, wouldn't be the first time.
I just seen on my email that to show proof of me being in the treatment facility. All right. Well, I was in IAC Associates. All right. Well, I had problems left and right getting them to contact me to get me in there good and all this. Okay. Well, I'm going this Friday to one up in Jackson. It was just too far. I wasn't going to go there. But I got me a ride now, so it'd be a lot easier for me to just go on and go up there every once a week.
Okay. Well, I mean, can you have them send something in and you don't have to get on a Zoom call and sit around for 2 hours. If you can just have them send something once you go meet with them.
Yes, sir. I can.
Tell you what, let's, can I give one of y'all's email address? Can I give it to you? I mean, can I give him yours?
You got a pen and paper?
Yeah.
Let me get me some paper right quick.
It's all just one big old word in it.
All right.
Can you see, hold on, I find myself. Can you see that?
Jennifer Hayden at kycourts.net. Let me write that down. I won't remember in 10 minutes, Your Honor.
You can write it. That's fine.
Jennifer Hayden at Okay, I got it written down.
All right. So just when you get in there, have them, you know, they write these letters all the time. They'll know, just have them write a letter and say that you've come in, you've whatever, gotten oriented, whatever they have. And you know, you're coming to meetings or coming to sessions once a week or whatever it is. Okay.
Yes, sir.
Thank you, Your Honor.
And then when you get it, when you start, you know, if you get close to getting that sucker wrapped up, maybe they can send another letter.
Yes, sir. Yes,
okay.
Sir. Do y'all know the next time I need to get on the Zoom app with y'all?
Well, right now, I think your next hearing date is not until April.
Oh, okay.
What day is it, Crystal?
It's the 31st.
April 12th.
Okay. At 10 o'clock?
Yes, sir.
Okay. I'll see y'all then.
All right. Be good.
Thank you, Your Honor.
Judge, was Robert Horton moved?
I think he's on the afternoon. We had,
Okay.
he's one of, I think, 3 people in Hart County, and they wanted to do it this afternoon, so
Okay.
for whatever reason.
Is
Judge,
Tina,
we do have Terry Lunsford down there at the bottom for an arraignment.
Oh, okay.
Judge, real quick, I was going to ask, is Tina South one of those 3 in Hart County that got?
Yes.
Okay.
Be careful what you say.
All right. You, Mr. Lunsford?
I can see you now. Can you see me okay?
Well, I could see you until you started talking, and then your video, and then you disappeared.
Okay, I'm trying to
there you
fix
are.
it.
Yeah, I got you.
Can you see me now? Okay, there we go. Sorry about that.
It's a fluid situation. All right. Lunsford, tell me your address, will you?
It's 205 Fraser Avenue, Glasgow, Kentucky.
Okay. All right, and you're here because you got indicted by the grand jury back in 24,
May, I believe.
Yeah, for criminal possession of a forged instrument and theft under $500. The criminal possession of a forged
That's right.
first degree is a Class C felony. The theft is a Class A misdemeanor. Do you need me to explain your rights to you, or have you caught all that here today?
Your Honor, I know my rights and all, but I would like to hear the on the forged prescription.
Yeah. This is all I know is what the indictment says, okay, which the indictment is just required to have the minimum information on it. The grand jury charges that on May 21st, 2020 in Barron County, Kentucky, the defendant, Terry Jonathan Lunsford, committed the offense of criminal possession of a forged instrument in the first degree when, having knowledge that an instrument was forged and with the intent to defraud, deceive, or injure another person, he uttered or possessed, which means uttered means passed or handed, or possessed a forged instrument of a kind described in KRS 516.020, specifically a counterfeit legal tender $5 bill.
Yeah. Yeah.
All right. So that's what the allegation is there.
Okay. I guess whenever we move forward with it, so this is my arraignment. So today I'll just plead guilty or not guilty, correct?
Yeah, all you need to do right now is tell me whether you are going to hire a lawyer or do you want me to appoint you a lawyer?
Well, Your Honor, I do. I work 40, 50 hours a week, but I'm the only one in the house working. My wife doesn't work. I would like to have a public defender if I could.
Yeah. I think I can do that because I think I think you had a public defender. Well, Mom, maybe you didn't at district court, but
I'm not going to sit here and go into it with you over that counterfeit money, but
no, yeah, let's don't talk about that right now.
Yeah, I'll talk to you about it. Or
you'll talk. I'll appoint you a lawyer.
I can tell you
a lawyer about it.
Talking today. Yeah, I'll talk to him.
Yeah, you can talk to your lawyer about it. All right, so we'll appoint you an attorney.
I'll represent him, Judge.
All right.
Mr. Lunsford, you got a pen and paper to write down my phone number?
I do right now. I have it. You go ahead and tell me.
Okay. It's 833-385.
833-385.
6055.
6055.
Yes.
And what was your name, sir?
Greg Berry. If you call me, they'll put you through to me or send me a message you're trying to call me.
Okay.
Mr. Barry, just because I don't know when, I don't know when we're going to be in person again, and Mr. Lunsford, he's out on bond. He was actually, I think he had moved, so he never got served with this, but somehow found out about it and called and,
Okay.
ask to
Yeah.
participate.
I
So,
was,
that's a good sign. But I'm going to go ahead.
I was wondering why. I apologize. Go ahead.
Well, I was just going to say, I'm going to go ahead and set your pretrial conference on April the 19th, which is a little ways out, but, hopefully we might be having court in person by then. It's a lot easier if you can come in person than to do this Zoom stuff.
Yeah, and have to miss work and everything. I would just be glad when all this is over with, honestly. Can I ask you, is that what's took so long? Because I've been waiting for like almost going on 11 months. It's been 10. I was wondering what took so long. Finally, I've been calling and everything.
Yeah, there's a lot of things. I mean, back in the summer, when all this back in the springtime, when all this first hit, the grand jury wasn't even meeting and indicting people for a few months. And then when they did, they only mainly indicted people that were in jail, to get their cases moving along. And so when they did indict you in September, we sent a summons out and it got returned that you had moved, and then we quit having court in person again. So your cases, your hearing date keeps getting moved, but you're not getting any of the letters because moved from that address. So that's why I wanted to get your address, so you'll get it.
Yeah, I got it all fixed and everything. So April the 19th, Your Honor, is that?
Yep. Just call Mr. Barry before then, okay?
Yes, sir. Can I ask you one more question? I'll leave you and let you go.
Okay.
I've been going to U-Turn for almost 10 months now. Paying them. I work a lot, and that's the only, I wouldn't mind going. I just, whenever I have to leave my boss, he gets mad and it's interfering with my job. I'm not going to run off. And I know if I did run off, I'd get caught. I'm getting too old for that. If there's, it's like a different kind of something you can do for me.
Well,
so I don't have to keep reporting to them.
Yeah, here's what we'll do. We'll take that part off of your bond, because I looked in here and they haven't sent any violations or anything, since you've been meeting with them.
I've been going to them. I've been doing everything I'm supposed to do.
There's no violations in here at all. And, you've been, like you said, you've been going to them since May.
Yes, sir.
9 months, however long that is.
Yeah. Like I said, I'm ready to get all this over with. And
all right. Well, just call Mr.
April
Barry.
19th, and I'll contact Greg.
Yep. Good deal. Thank you.
I'll do it, Your Honor. Thank you, sir.
Be good. I don't know. Does it look like it's everybody?
How do I come out of this, honey?
I'll
We've got
get you out.
some like diversion reviews. Other than that, I think it's everybody.
Yeah. Thank you. Ronnie Allen.
Hey, Judge, I got a note here, and I don't really know what's going on, but it said something about transferring out of state. I don't know if you got anything in the file that talks about that or what's going on. I think he was supposed to pay some restitution.
Yeah, I have a note here that on the docket that says transferred out of state, but I don't have any idea what that means unless it means his probation was transferred out of state.
Wasn't he in court just not too long ago?
It was over that.
Oh, Crystal is saying that somebody called and said he was in jail out of state.
Oh.
I don't know what transfer of businesses, but he has not made any payments for Right Smart, wow, since July of 2019, so 18 months.
Judge, was he the one who said that if he got out, he had money waiting for tax returns or something like that? And he was gonna pay up as soon as he got that?
I think you're right. Back in December or January or early January.
Right, that's what I thought.
I guess that's why they're saying transferred out of state, is maybe he had a case in Tennessee and they came up here and got him or something and he didn't get out.
Gotcha.
Well, I'm gonna put it off for a minute and we'll see if he comes in and makes any payments. If he doesn't, he'll.
And I'll try to look and see if it was a case out of state, find out what's going on with that, so we have an idea when he would come back.
Crystal said Tennessee, so that narrows it down a little bit.
Judge, I'll call his officer and see what's going on with it. His officer before he went out of state or whatever happened, and see if he knows anything.
Yeah, cool. Here's what we're gonna do. We're gonna put him on for a show cause on August 2nd. At that point, it'll be over 2 years since he made a last payment unless he starts paying. So, I mean, I won't feel too bad if we have to do something.
Sure. Hey, Wesley, if you find out anything, can you email me?
Yes, sir.
Thanks.
All right. They don't know how these people don't know how good they got it up here. Patricia Coates.
Your Honor, she still owes restitution in this case. It's a benefits case. I think we've checked on it, and last payment was made was back in May. So we'll probably be filing a motion in that case.
She made a payment in January. Might have been after you all checked.
Okay.
She called. Yeah. She called back last month and said that she she was paying as of last, well, it may have been 2 years ago. But anyway, she had, I guess, lost her job or whatever because of the virus, because of COVID, and that she was going to start making her payments again. And she did make the first one. So I think Crystal says we told her that we would pass it to for a year to review. Now, if you file a motion, then that's up to you, but that's what we told her.
Nobody's contacted us from the cabinet or anything like that, so we might wait until if she started paying again.
Yeah. So I guess that's December 31st. We'll call it February 7th.
That's 2/7/22.
Uh-huh. All right. All right, let's see. Moving on down the old list here. Charles Franz.
That's okay to be dismissed, Judge.
Okay.
Actually, Franz, and then I think the next one is Robert Whitlow, and it's okay to be dismissed as well.
Robert Whitlow. Okay. Oh, sorry. And then let's see. I don't know. Elizabeth Osborne is the one that way back when she was in jail in Fulton County, and we tried to set up a Zoom hearing to arraign her, and they said they didn't Zoom. They kind of acted like they didn't know what we were talking about. And it was a while ago. It was like July. And so we went looking for her again, and she's gone. She out of jail. But I thought part of the reason she was in jail was because of being on probation in Metcalfe County, and we had done a warrant on her. So I'm not sure how she got, but maybe we had revoked her and she just served, like got paroled out or served out or whatever. So I don't really know what her status is. But tell you what I'm going to do. I guess, since we have a probation officer on here kind of listening, if they can track down where she is and get her notice of this, fine. If not, I can issue a warrant then. I'll put it off to March 1st for an arraignment. And we'll issue a whereabouts unknown deal because I don't know where she is now. I probably won't know in March either.
I'll do my best, Judge. Also on this Linda Choate or Choate we was talking about earlier, she is listed as incarcerated in Warren County. She's on their website.
Yeah, I think that just whoever made the docket up didn't know that at the time, but they know now. I think they're going to try to get her on this afternoon.
All right. Thank you, sir.
Oh, Ronnie Allen is in Sumner County, Tennessee. He got extradited. There was a case in district court where they served out of state warrant on him and he got extradited. So where he is.
Your Honor, Brian Graves, he is one of mine. I think he was scheduled for an arraignment today. But he's got, I think he's maybe in the Boone County Jail.
Yeah. He's on the 130 docket.
Okay.
To arraign him. Yeah.
Okay.
Brianna Wilson is on a drug court review, but she absconded from drug court a long time ago and she's had a warrant out on her. So she got expelled from drug court in September of 2019. She's been in the wind ever since. You all have a pending motion to void her diversion. See what else you got. Whitley County, Jonathan Yunt. Yeah, apparently he's in the Whitley County Jail. You guys have a motion pending to revoke him. So I guess maybe we'll try to set that up next week and get him on the.
Judge, I just looked up this Elizabeth Osborne. Looks like she just made parole on the 25th of January. She looks like she's in Owensboro. I'll get an email to her officer saying she needs to be available for court on 3/1.
Super. Thank you.
Thank you.
This Jonathan Yunt, you all may remember, was in Whitley County Jail back in the summer. He had an attorney at that time that got on via Zoom, if my memory serves, and we agreed to extend his probation for a year in lieu of revocation. Apparently got out and at least allegedly never reported, and now he's got a warrant again. They say he's in Whitley County, so we'll try to him back on the docket for Monday. We'll get somebody to reach out to Whitley County. I think we got him once before. Is that it, Jennifer? Good Lord, every time I think we're done. Oh, yeah. Brittany Decker, you all have a motion to void or pretrial diversion. It looks like she got arrested in Hart County, so she may turn up this afternoon she isn't on the list, but if not, we'll talk to them about her if somebody reminds me.
I think that one's mine, Judge. I'll bring it up.
Okay, thanks. All right, believe that's it.
Judge, Josh, you there?
I'm here.
Okay, got your email read about Natasha Woosley. My understanding, that email, she's been granted shock in Ohio County.
Yeah, he